All right, still with me, civil rights attorney and former criminal defense attorney DeWitt Lacy. And DeWitt, so there it is, essentially he's testifying that Kim Potter's mind sort of went into a sort of autopilot. He calls it action error. He calls it slip and capture error, which was interesting because on cross, it was brought out by the state that that was his own term. He coined it, he applied it to police officers. So they tried to paint it as junk science. I'm not sure how effective they were at doing that because it really, some of the stuff he said is just basic common sense. But your thoughts on Lawrence Miller's testimony?
Look, I think he testified in a convincing manner, right? He certainly had all the right things to say. However, I think logically, the logic fails him, right? Because the standard that they're going to have to judge Potter by is whether or not she was a reasonable officer. And whether or not she had this experience of slip and cap error or whatever suggestible psychological error this doctor may have been suggesting, the real point of evaluation that the jury is going to be asked to do is whether or not that was a reasonable for regular officers. And I don't think that they're going to be able to sell that story.
Now, if they can't sell that particular story, I think they have a better chance, and this is the argument we were starting in the last block. I think they have a better chance with the reckless use of an arm, of a weapon in that first-degree manslaughter rather than the culpable negligence, which requires a conscious disregard of a known risk. Basically, it feels to me like the language, and we'll find out exactly how they're charged tomorrow on these particular charges, but it sounds to me like they're going to have to think that she knew that the gun was in her hand and disregarded that danger. With the reckless use of a firearm, I think there's more of a chance for them to look at it and say, there's no way she should have made this mistake as a 26-year veteran, trained over all these years. We can't let her get away with it at this point. I think that's where the first degree comes in as opposed to the second degree. Your thoughts?
I think that's fair. And maybe what we've just discovered here, Michael, is that these things are not mutually exclusive. It's kind of not a one or the other, because even if she believed mistakenly that the firearm that she had in her hand was a taser, the question is whether or not it was reasonable to fire at someone who was about to be driving a moving vehicle. Any police practice expert worth their salt is going to tell you that that's not what is trained in the academy, that you don't do that. You don't shoot into moving cars. Because if you are successful at disabling the driver, then you've just launched an unguided missile upon the community and society at large, which is, of course, extremely dangerous. So officers would not do that. They're trained not to do that and to understand that risk when pulling the trigger. So whether or not she was pulling a firearm or a taser, the idea would have been to incapacitate Mr. Wright, which would have led to this unguided missile, and it's against policy. That's not what a reasonable officer is trained to do. I think the prosecution's going to have the testimony to be able to prove that.
Well, that's a problem, though, DeWitt, because they had at least 3 active officers take the stand and say the opposite, that under those circumstances, deadly force was proper. I think there was a slight admission by Kim Potter on the stand today that perhaps it may not have been what she was thinking of doing, but all these guys you're seeing here, all of them, the use of force experts, Stephen Imes to Timothy Gannon, the guy who was her commanding officer as chief. You also had Officer Johnson. They all testified that use of deadly force under those circumstances was appropriate. And that's where I think a big problem for the state comes in.
Yeah, I think you got a point there, right? Especially if they're successful in that for the first degree, right? But I think the second degree is still there. Even you can have both theories, right? Either case, what the defense will argue is, even if she did pull her gun, it was okay because that was what was required or what she could do as a well-trained law enforcement officer, right? But there will be folks on the other side who can combat that type of narrative. And really, I think what it's going to come down to is this reasonableness, right? Whether or not it's reasonable for somebody of her experience, right, and veteran experience to make those type of mistakes, right? I think the new theory that, and I call it new because initially it was about the taser, the newer theory is that she was trying to protect this other officer. And I think that falls flat on his face, personally.
All right. That's interesting, because I believe that's what the state's arguing here as well. We'll have to see how it all plays out. I think the jury charge is going to be very, very important. We'll be paying close attention to that coming up on Monday morning. All right, stand by, DeWitt. We're going to take a break now, and our coverage of the Kim Potter trial will continue after this break. We're going to take a look back at the state's entire case. Did they prove their case beyond a reasonable doubt? That's questionable. I guess I have a reasonable doubt about that. When we come back, all that and more. So keep it right here on Court TV.